Good afternoon, everyone. I'm David Glazer, and I'm not actually talking today, but I just wanted to come in and do a couple of quick things, a couple of quick announcements. First off, today launches the beginning of our 8th year of webinars, which terrifies me a little bit and explains some of my gray hair. It means webinar 100 is just around the corner. Our next webinar will be on December 11th, 1 month from today, and that's going to cover the physician fee schedule, assuming it comes out by then. It's late this year. The rumor has it that it will be out the last week in November. The government shutdown delayed the fee schedule. We'll also be talking a little bit about the inpatient prospective payment rule, and most importantly, even though we've done a webinar on this, we're going to cover the 2 midnight rule again. So we will be talking about the 2 midnight rule as well as whatever's in the physician fee schedule next month. If you're interested in that 2 midnight rule, you can remember all of our recent webinars now appear on SlideShare. This webinar will appear on SlideShare. You will be getting a link that can, as soon as it's posted, that will take you there. So instead of getting a CD of this, you can watch it online. You can forward that to anyone you want. Feel free to do so. We often get complaints about the internet sound slowing down in the middle of the webinar. We can't control that, and nor can you. If it happens, just please use the dial-in number. Final important administrative point, you now see this in full screen. If you want to ask a question, there's something you're going to need to do, so pay attention for a second. If you take your mouse and go up to the very tippy top of your screen, right in the middle, you see a little box. Hover over that, and a toolbar will pop down. On that toolbar is the box labeled chat. Click on that, and you can type in your question, and Briar and Carrie will be happy to answer them. So with that, I'm going to introduce quickly Briar Andreessen and Carrie Rosenberry. In the old days, I used to feel like I could do things, and I was kind of a jack of all trades. And if I had gotten an IT agreement, I would look at it. Those old days are long gone. I now realize that I'm committing malpractice if I were to try to read an EHR or health IT agreement. Some of the things I think a lawyer could figure out there, if the vendor says they can raise their price at any time. But I know Carrie has saved many a client from that one. But then there are terms I don't even understand, uptime guarantees and the like. We've had a bunch of clients get into really ugly fights over the health IT situation, and I know both Briar and Carrie have dug people out of those big fights, and in some cases, more importantly, prevented them from happening by working on the front end of these. So, without further ado, I'm going to turn you over to Briar Andreessen, and she and Carrie are going to walk you through the important stuff.
Thanks, David. And I'm going to just kind of give the brief overview of what we'll talk about. The current landscape for information technology in the healthcare world, what's required for an EHR. And I should note here, the focus generally is going to be on the EMR, EHR, but many of the issues that we'll talk about that Carrie and I are going to cover a little bit will also apply to other types of health IT agreements. So we'll talk about EHR and EMR, and we'll use those terms interchangeably, but keep these in mind for sort of general health IT things. We'll talk about tips for selecting a vendor and what should be in your agreement, and Carrie's going to get into some specifics about that. So getting electronic, the obvious trend here is towards having an EHR and EMR in all types of practices, and obviously you're on this call because you have some interest in it. Meaningful use is a big part of healthcare practices going electronic, but even non-meaningful use practices are going in that direction. I've got a couple of bullet points. Is it a relationship builder, and does it provide better patient care or efficiencies within the clinic or the hospital setting? And I think the tide has started to turn on that, and providers are buying in more than they used to, saying, okay, it's a pain in the neck to start, but generally seems to be worth it in a lot of cases. There is, according to the healthit.gov website, 94% of providers report that their EHR makes records readily available at the point of care. 88% say their EHR produces clinical benefits for the practice, and 75% of providers report that the EHR allows them to deliver better patient care. So some studies also have shown that patients do make decisions about where to go based on whether the practice has an EMR. So it probably is worth it, even if you're not going to be going for meaningful use. Well, there are those statistics for you. So some barriers to implementing health IT. Money is the biggest one. It's a big capital investment required, especially if you're replacing a full EMR. Some solo and small medium groups are the least able to spend the necessary money, and we'll talk a little bit about getting donations for that from hospitals. There's some practical difficulty too. The health information technology doesn't decrease the need for resources within an organization, it just shifts the allocation. So hospital IT departments are a lot bigger and busier than they used to be. And then there's just the question of, are providers buying into this? Are they willing to do this? Are they willing to learn the system? Or are they throwing up their hands and saying, I'm too old to learn about it? And then sometimes the systems don't work as they should. If you can't do what you want or need them to do, that's a big problem, and it makes your system just a really expensive waste. And then sometimes you're not getting the help from the vendor that you need to make changes to the system or improvements to the system. So we'll cover a little bit of that and how you can hopefully avoid it. The meaningful use stuff, this is maybe the biggest regulatory issue with EHRs right now. It provides big incentives for providers and for hospitals that are meaningful users. And then keep in mind, in the clinic setting, payments don't go to the practice. They belong to the physician unless the physician reassigns those payments. It's not an automatic thing that they would go to the practice. And the money that gets paid out is not tied in any way to making payments for health information technology. That money can be spent on anything. And unless an employer of a physician tackles this on the front end, it could end up to be a nasty surprise when you have physicians that are just collecting that money that you thought was going to be used to reimburse the practice. So there will be penalties coming for people who are not meaningful users. There will be a discount to Medicare payments. There's no discount for Medicaid payments. So if you only see Medicaid patients, it's not as big of an issue to become a meaningful user, but for others, it probably matters. Different stages of meaningful use have different requirements, and vendors should have an obligation to meet the requirements for each stage. That should be part of the agreement. It should allow you to report, to attest that you're a meaningful user if you meet the criteria. And that's important. And we do get pushback from vendors saying, oh, well, who knows what stage 3 is going to be, so we can't possibly agree that we'll be compliant with stage 3. But they can figure it out. My position on that is they can do it, and they're going to have to do it if they want to remain in business, so it's worth it to push for that. You do need to use what they call certified EHR technology, CEHRT sometimes, to be a meaningful user, and that website directs you to the list of certified EHR technology. E-prescribing, I'll kind of skim through this. It's another chance sort of for free money or to lose real money. You can get a downward adjustment for failing to e-prescribe. Or unless you are using this or demonstrate your intent to participate. So e-prescribing is an important thing, and the DEA did modify their regulations to allow Schedule 5 drugs to be Schedule 2 through Schedule 5 to be prescribed electronically, and states are changing that on a state-by-state basis too. And this, I'm just going to really skip through the next couple of slides talking about what needs to be in e-prescribing software, because the point here is that if you need a particular feature, if you need to do a particular thing with your EHR, you need to make sure that that system is able to do that stuff. So pay attention to the documentation that your vendor provides to you that says what it does, and if something is not there, if it doesn't indicate that you're going to be able to do this type of thing, make sure that that gets added and make sure that you ask questions about that. So HIPAA obligations are another part of the EHR, and one thing that you want to make sure your system can do is comply with all of the patient's rights obligations that there are. So the right to amend, the right to have access, the right to request restrictions, and the right for, to have an accounting of what disclosures have been made. In most cases, there are ways to do that with EHRs and to do workarounds if you need to, but it's worth it to ask up front, how are we going to be able to, if a patient requests a restriction, how can we limit that information? Can we put flags on? What can we do with this to make sure that we can comply with those requirements? A new-ish requirement that came out in the last set of HIPAA rules is if a person requests an electronic copy of their PHI that's maintained in a designated record set, you have to provide access in the electronic format requested by the person if you can, or otherwise in a readable electronic format as agreed upon by the covered entity and the individual. So Most systems should be able to produce those electronic copies, and you also have to make sure if the EHR has links to images or other data, you can also include that in the electronic copy provided to the individual. So that's just another thing to make sure your system can do. You also want to make certain that you execute a business associate agreement with the vendor. You can review the functions that the vendor is going to provide, but it would be fairly shocking if they did not meet the criteria for business associates, because the new definition says if the vendor creates, receives, maintains, or transmits, or needs to have access for troubleshooting, if they have that access to PHI, if they maintain PHI or transmit PHI, you need a business associate agreement. The government has said that an entity can be a business associate even if the vendor doesn't view the information, and they discuss in great length the transient versus persistent nature of the opportunity to view the information. And essentially they're trying to make a distinction between the post office, for example, and a vendor. The post office has a transient ability to access the information, whereas a vendor who maintains servers or something like that has a persistent opportunity to be able to look at that. So vendors, even if they are, in the cloud, they are going to be business associates. We have seen some pushback from some vendors on that, and if they refuse to sign a business associate agreement, that to me is not a very good sign about your vendor. And keep in mind, you can report a business associate to the Office for Civil Rights, which is the government entity that enforces HIPAA. You can report to them, listen, this company has our information, they're refusing to sign a business associate agreement. Please do what you can. And the head of OCR has said informally that OCR wouldn't go after a covered entity for reporting a business associate for something like that, for a refusal to sign. They're not interested in going after the covered entity for failing to have a business associate agreement in that case. They want to know that the business associate is being a bad actor. Another thing is get indemnification that is specific to business associate agreement and breach issues. And that can be either in the main vendor agreement, or it could be part of the business associate agreement, or it could be in both spots as long as you're not undercutting yourself in one place or the other. But there is a high potential for a lot of damage if the vendor is either careless or just sort of generally negligent, or is actually really bad. If something happens to the PHI when it's in the electronic health record, it can be all of a sudden thousands of patients that are involved, and that means probably forensic investigation to find out what happened to it. It includes notification. It might include fines from the government. So make sure that you are covered for things that are not your fault related to those breaches. Also pay attention to the HIPAA security rule. The security rule was ignored for a long time by covered entities and by the government, really. But it's becoming a bigger focus for the government, and therefore becoming a bigger problem for practices. So work with your vendor to identify and mitigate potential risks related to the security rule. You're required to have these administrative, physical, and technical safeguards in place, so you want to make sure that you do. And one big piece of the security rule is having performed a risk analysis and updating the risk analysis. And OCR has been pretty clear that you need to update that risk analysis every time the system gets updated or upgraded. So anytime there is a change in your IT environment, you need to take a look and do the risk analysis and see if there have been any changes that you need to deal with as far as mitigation of risk. More HIPAA stuff. Keep in mind what access is appropriate for what kinds of users of your system. Does your system let you limit access, and do you need to? You should include it in your own policies if you can, saying who gets to have access to this and who doesn't. And keep in mind as you're doing that HIPAA does have minimum necessary requirements that say essentially only the people that need access to the information should have that access. And that's true both internally and when sharing records within an interoperable system. So internally, make sure that only the people who need it can get it. And if you're sharing records, if there's an interoperable system, if your hospital allows clinics to have access to the system, make sure that there's a minimum necessary analysis there too. And then make sure that you can track unauthorized access, or that you can verify that access is unauthorized. Break the glass is one typical system where A screen pops up when a user tries to access a system if they haven't looked at that record before, if they don't have an association with that patient, and it's essentially a warning that just says, are you sure you want to do this? And tracking that unauthorized access is really important in shared systems or in standalone systems. You really want to make sure that you can figure out who's been in what record. And sometimes it's very disturbing when you find out who's been in what record, but it's important to know that so you can follow up and fix it. Medical record issues, we'll just skim through that. These are kind of questions that are out there. Who owns the information? How are you going to track ownership of certain, when there's a shared patient? Which party in a shared system is responsible for making disclosures and complying with requests? And what happens when one organization breaches another organization's information? Again, a clinic has access to a hospital's record, and some clinic employee goes and just searches through hospital patient records for no good reason. You need to figure out who's going to deal with that, who's going to notify the patient, who's going to notify the government. Can patients opt out of medical records and state law consents? Who's responsible for getting those? Those are just things to kind of think about, and if you have partners in the EHR, figure out how you're going to handle it. Other privacy issues, drug and alcohol treatment information is specially protected. There are specific research issues, so can your system deal with those? So think about whether you need to deal with them, and if you do, then make sure that those are reflected in the documentation that you get from the vendor. A brief mention of the federal law on donations of EHR. The anti-kickback law and Stark law, of course, both prohibit hospitals from giving anything of value to their referral sources unless there is an exception or a safe harbor. There is now a safe harbor for e-prescribing, and there's one for EHR, and the goal is to promote the adoption of health information technology. Keep in mind you don't have to fit the requirements of a safe harbor and exception. A hospital could provide items to a clinic at fair market value, but if a donor wants to provide information technology at less than fair market value to a referral source, you need to comply with the exception and or safe harbor. It's up to 85% of the cost. They're really detailed and complex regulations that I'm just going to skim through because I want to make sure we have plenty of time for Carrie to talk specifics. And these are kind of rules that you can look through, including before the receipt of the items, the physician or clinic has to pay 15% of the cost of the items, and that cost can't be, that 15% can't be financed by the donor. You can't directly take into account volume or value of referrals between the parties, and then a little bit more about that again you can read through if you care about this. Right now, the transfer of the donated items needs to be satisfied by December 31 of 2013. There's a proposed rule that would extend the date to December 31, 2016, but I'm not aware that that has been finalized unless they really snuck it in somewhere that I was not able to see. I don't see any reason why they wouldn't finalize that, so I do expect it to continue, but right now that's a little bit of an open issue. Interoperability is another requirement for the donation, so I'll just skip through that. This is a list of the items and services that are permissible. They can donate these type of things. These are the things that they can't donate any part of. And the biggest one there is hardware and the operating software tied to the hardware's functionality. So then I'm just going to conclude with a few things from the Joint Commission, and many of you on the call are not Joint Commission accredited and don't really care about the Joint Commission, but they do have some reasonable suggestions for EHR implementation, and I've put in bold there a couple of the ones that I think are most important. The first one there is actively involving clinicians and staff who are going to use and be affected by the technology, along with your IT staff when you are planning and selecting and designing your system. You want to make sure that you can get buy-in early on, and that is really the best way to do it, and the best way to make sure that people don't hate you and cause a huge backlash after you get the system installed. And then develop and communicate the policies, who's responsible for implementation, use, oversight, and safety review, because that is stuff that can fall through the cracks if you're not careful, and it is important to make sure it's taken care of. And then a few other things from the Joint Commission, but many of them are kind of common sense things. So I'm just going to pass it on over to Carrie now, and she will fight through her cold and talk to you about how to do this in the least painful way possible.
Thanks, Briar. Hi, everyone. I'm Carrie Rosenberry. I work with clients on technology transfers and excuse me. I am suffering through a cold, so I'll try to get through this without being too nasally. I work with clients on technology transactions, and when it comes to healthcare clients, that's typically IT contracts. I've worked on a number of electronic medical records licenses and negotiations, but also practice management software, imaging software, patient portals, there's a number of different ways that healthcare entities license technology. So today, while my comments will be focused mostly on EHR, this is applicable to any software or IT system that handles PHI or is otherwise business critical. So let's talk first about selecting your software vendor. I can't stress enough the importance of selecting the right vendor. Briar touched on this a bit, but it doesn't matter how good your contract is if the solution or the vendor just isn't a right fit for your organization. A good contract is going to help you, but it's not going to save the day. I wouldn't go so far as to say I'd take a bad contract over a bad vendor, but let's talk a little about selecting your software vendor, because if you've done your due diligence up front, the contract's going to back you up in that, but the due diligence up front is going to hopefully stave off some big issues. So to do your due diligence, get references from other companies that are using this software, especially if they're similarly situated to you. Talk to those references, go see how it works in their organization, see a demonstration of the product. I'm sure a software vendor is going to show you the product, but make sure you spend some time on that.
And if I could just pop in for 1 minute, sometimes if there's a major problem and somebody gets out of their IT agreement, the IT vendor will have them sign a confidentiality agreement that says they can't say any bad things about the vendor. And so if you ask somebody if they had some particular software and they say yes and they don't want to say anything else about it, I think that's generally not a very good sign.
Yeah, that's a great point, Briar. My last point on this was just, if you can visit their server site or see how physically they're set up and where your data is being stored. So moving down the list here, Briar talked about having a selection committee with users, be it physicians, nurses, staff, your IT group, your administration. Even consider hiring an IT consultant if this is a big purchase for you and you need some help and expertise there. Know your functional requirements going in. What functionalities do you need to fulfill your objectives? And also your technical requirements. Does this software interface with your practice management system or other software systems? What are the technical functionalities of this software fulfill regulatory requirements like meaningful use? You'll select your software based on pricing, certainly. There are lots of different pricing models when it comes to software. It may include upfront costs or monthly subscription costs only. There's maintenance and support, either way you go, costs for training, implementation, costs for converting your data to work on your new system. And another sometimes hidden cost is a cost to update your existing system. Do you need to buy a new server? Do you need to upgrade your Microsoft software? Sometimes that can be as big of a ticket item as some of the implementation costs themselves. When you're selecting your software vendor, consider whether you want to use a cloud-based system or an installed software system. The trend is definitely towards cloud-based, also known as software as a service, subscription, application service provider, ASP. But you do still see these big software systems working as an installed system on clients' software. So just to hammer this home a little bit, the two different ways of licensing software is to have it either installed on your own servers, where all of your data and software is kind of held at your location or wherever the client stores their servers. The updates are done individually on each computer, on each server, at each client site. The client is in charge of its own disaster recovery, fire protection, physical security. Alternatively, we see a lot of movement towards cloud-based software where it's a shared system hosted and managed by the vendor at a central facility. For a lot of, and typically a lot of very similarly situated healthcare clients are running the same software. It's more scalable this way and more cost-effective for a client. They don't have to invest in all the hardware, the physical hardware, but it's a little scary knowing that all of your data is held off-site and by this vendor. So we're going to touch on some of the ways to mitigate that, but certainly the trade-off of the cloud-based system is that the data is out of your hands. Another important thing to consider when selecting your software vendor is security. I suggest putting together a questionnaire for your vendor on security topic that discusses how PHI will be handled particularly. Ask about their documented security policies, physical security, how who's allowed into the server room, what are their backup and disaster recovery procedures, and where will the data be stored? Is there offshore data sites, or is this all here at home? Is your data segregated from other clients? Are you on your own server, or is the server partitioned, or is all of the data not mixed together? But is what's the vendor doing to separate and segregate data? And then also, has the vendor had data breach incidents, and what were the circumstances and how were they handled? Finally, will you use a bidding or RFP process? If this is a big purchase, that's certainly something to consider. Even if you don't, I suggest selecting at least 2 finalists as you go forward. You're in a better negotiating position with your chosen vendor if you have one in your back pocket to switch to if things don't go the way you want as we head down the contracting process and continue the due diligence. So, moving forward. Here are a few elements of an IT contract. Often the first thing you'll get is a proposal or a quote that has the pricing, the description of the software, what are the implementation costs. Maybe it shows you a big discount that you're getting. And despite what the vendor might say, this is almost always negotiable. After that, you'll maybe see some terms and conditions. There'll be the software license, perhaps a separate maintenance and support terms and conditions, or that could be wrapped into one. Another big item is the statement of work, the work order, and that outlines in more technical detail the implementation process, the minimum hardware and software requirements that you need. Then you'll see, hopefully, a service level agreement, particularly in the case of cloud-based or software as a service agreements. We'll talk about the service level agreement later, but that just gives some guarantees as to how the software will perform, how it will be available, how available the vendor will be to you when the system is down. And then finally, as Breyer touched on, almost always you're going to need a business associate agreement. And I echo her sentiment to include indemnification in that business associate agreement. All right, now I'm going to jump into a number of key provisions. There are lots of things in these contracts, but a few of them are more important than others, and a few of them are going to help you avoid issues. So first of all, there should be a place in the terms and conditions, or perhaps even the proposal, that describes the software and defines exactly what functionality you're getting. It's okay if it's in a technical document, but the contract should incorporate that somehow. The contract itself should say, at a minimum, the software will perform the functionality set forth in the technical specifications listed on Exhibit A, or the user documentation. Or even, don't be afraid to say the functionality set forth in the RFP response in the sales materials. You're going to have extensive conversations with the software salesperson, and they're going to make lots of promises about how the software will perform, and you'll talk about what your requirements are. But those conversations and that sales literature is not incorporated into the agreement and not binding on the vendor unless you make it specifically part of the contract. That's a key issue when there's a dispute down the road about why the software doesn't perform as you thought it would. If you have an email that said it would, but we haven't incorporated that into the contract, it's generally going to be excluded, and we're not going to be able to use that as evidence of a breach by the vendor.
And I think, Carrie, sometimes do they even say in the agreement, the initial draft that you get, it will sometimes specifically exclude those things?
Specifically exclude sales promises. Yes, I do see that often, and I strike it. The definition of the software is also tied to the warranty. A warranty I always like to see, or if I don't see it, I add it, that the software will perform as documented or as stated in the documentation, capital D documentation. So if in the event that it doesn't, we can point to a warranty and a breach of warranty. So basically, the more you have in writing on this point, the better position you'll be in. Don't be afraid to go back and document conversations you had by email and attach those emails right to the contract. And finally, regulatory compliance should never be assumed. If the EHR will be used to fulfill a regulatory obligation like meaningful use, let's state that specifically in the agreement, that the vendor will provide a product that's compliant with its regulatory obligations. And know that meaningful use is an evolving concept. So not only should the software be compliant now, but it should be maintained and updated by the vendor to continually meet that obligation, which is something Breyer touched on too. All right, moving on. Always important in these agreements is the pricing. Overall, as a strategy, know that pricing in IT contracts is negotiable, and your negotiating position might never be as strong as it is right now up front in the contracting phase. Once you've implemented and become reliant on your system, it's going to be difficult to go back and renegotiate the pricing to try to keep your maintenance and subscription costs down, or to try to, if you want to add a location or add a significant portion on to what you've already purchased from the vendor, they're going to be perhaps less likely to throw that discount your way. Another strategy to consider is to take advantage of end of quarter or end of year cycles for the salespeople. They're all often very motivated to close a deal at the end of the year or the end of the quarter to meet their numbers. So if I were to give you a few tips on pricing, aside from what I've already said, the first one would definitely be to hold back a portion of your upfront fees, either be it for license or for implementation, until you're using the software in a go-live real environment. This gives the client the chance to make sure the software works as it expects and that the upfront work gets done. Tip number 2, I think both of these are important, but tip number 2 is to tie payments to milestones and not just to the date the contract is signed. I understand some money may be due at signing. I'm not suggesting that you might never be required to do that. What I am suggesting, though, is that the next payment be tied to the vendor committing resources to your project or actually getting something done for you, be it implementation, data conversion has started, implementation was successfully completed, training has started, and a final payment due upon client acceptance of the software, or even 60 or 90 days after acceptance of the software, so we know it's working. Next tip is to consider what the annual increases in maintenance costs or subscription costs if you're doing a cloud-based system. A lot of times you'll be tied to, you might tie yourself to a several-year contract. And also if you're making the upfront investment in license fees, you hope for this relationship's going to be a couple of years. But what I don't want to see in a contract is the right for the vendor to increase their maintenance costs or their subscription costs at any time just by giving you notice. I've seen that in a contract. That can be pretty detrimental once you've installed, you've paid the upfront amount, you've been using for a while, your users are trained. The vendor decides to increase their price by 20% or even more. I often include language in the contract that caps increases to the consumer price index. I even, as a starting position, would say that if you've agreed to a 3-year deal, that the prices are locked for 3 years. I don't think that's an unreasonable position to take at all. So next up, how are the fees calculated? pay attention to the way user is defined, transaction, claim. Maybe you're paying by a certain volume of procedures or volume of patients, the number of images you view on through your imaging software. If you're paying a per transaction charge, the definition of that transaction could be important and could significantly affect your fees going forward. And finally, a tip that sometimes works, sometimes doesn't. Ask about future pricing. If you are considering another module that this software vendor offers, or if you know you're going to be adding a new location in a year or two, what's the pricing going to look like for that? Talk about it now rather than waiting till then and losing some of your negotiating power. So that's pricing. Implementation and acceptance testing, another key provision, of course. So implementation, language surrounding implementation is particularly important when you're doing some customizations to the software, when the software interfaces with your other software systems, which happens all the time, when the vendor is converting your data from your old system. Now, as a practical matter, a client's IT staff should participate in the implementation, so you're not solely reliant on the vendor. I suggest that failure to stick to the implementation timeline should be grounds for termination. This is a great question to ask the reference that you got early on in the due diligence. How did implementation go? Did it stick to the timeline you were expecting? What issues did you come across? Another key question to ask the vendor: have you interfaced with our practice management system before? How does your software speak to these other vendors' systems? If you know that the vendor's done it before, you're going to feel more comfortable that implementation's going to go better for you than if you're the guinea pig for this for interfacing with your other software vendor. Another thing to keep in mind with implementation is a change control process. It should be in writing and it should be disciplined. That's one way for scope to get a bit out of control, is for the vendor to promise one thing with implementation, dig a little deeper after you've signed and paid some of your money and got started and realize it's a much bigger and more expensive project than you were expecting. Some of that's inevitable. These are IT projects, but let's try to mitigate that by contract up front if possible. Acceptance testing, I also mentioned here, the customer should have a meaningful opportunity to confirm that the software functions in accordance with the documentation. Testing is an important step that shouldn't be overlooked and shouldn't be skimmed through, because you're going to have to live with this software for a number of years. If the customer identifies a deficiency during acceptance testing, the contract should allow them to have the vendor, require the vendor to correct that deficiency within a given time frame, and then give the client the right to retest. If the vendor is still unable to correct the deficiency after further testing, here's where the contract should give the customer the choice to either terminate with a full refund of all amounts paid, or to give the vendor more time to achieve acceptance. I understand why you might want to go through this process a few times. You've invested in this vendor, you've invested time and doing your due diligence and signing a contract with them, but I don't think the process should just go on forever of them trying to cure that deficiency. If you don't have language in the contract that says you get a full refund, you're probably not going to get a refund unless you can prove a breach. So better to get that language up front. Training. Once your software is implemented, your users will, of course, need to be trained on the new system. The contract should address training in a way that works well for both sides. A fee structure for training should encourage efficient use of your clinical staff and staff's time. If the vendor gets paid by the hour for training, for instance, that's a conflict between the vendor's financial interest and your financial interest. We all know that clinician time is valuable and training is not popular. Key personnel, this is an area I like to focus on. A common theme in IT projects that end badly is staff turnover. No one wants to see their key project manager move to a different project in the middle of implementation because that vendor signed another big healthcare client. But if that happens, we can by contract try to prevent that from happening. And I'll add a clause that says that certain key personnel, be it the trainer, the project manager, your lead whoever, will remain on the project so long as they remain an employee of the vendor and will not be moved to another project. Unless, of course, they leave, they're no longer employed, or unless the client requests otherwise. If it's not working out with that person, I like to add language that says the client can have the right to have someone removed or moved off the project if they aren't working out, if they're not responsive to our needs, really for any reason, so long as that reason is legal and non-discriminatory. Finally, an issue that comes up with both in implementation and in training is travel costs. This is an area where you see some scope creep and prices rise fastly. Some of this work can be done remotely, even training I'm seeing done remotely more often. But a few things to consider in the contract to cover yourself is that, first, all travel costs should be approved in advance by the client and should be documented. Review the vendor's travel policy and have it incorporated into the contract, or use your own travel policy. I have lots of clients who prefer that. They have their preferred hotels and car rental, maybe a deal with a car rental company, meal limits, etc., that can keep costs down. Another thing I see clients do is to add a not to exceed number for travel costs, so they can budget what it's going to be, and the risk would be on the vendor to stay under that. Or just simply include travel costs as a line item. Travel is going to be $20,000 for this deal, and it's up to the vendor to determine how it's spent and what kind of hotels they're going to stay at. But if it goes over that, that's a risk on the vendor's part. So another way you see, on the really big deals, travel costs maybe are less of an issue, but it's a good place to keep the vendor in check. All right, let's talk now about termination, and transition. The term of the contract will depend on the type of software you've got. If you're a cloud or software as a service, I wouldn't commit to more than an annual or monthly renewals. There's not a lot of upfront costs here for the vendor. And in my opinion is that the client should be able to terminate for convenience at any time there. You would be out your upfront costs of implementation or training, but because the cloud-based system is a shared system, the vendor probably isn't investing a lot of extra money on their end to have you added as a client. So they don't have a great argument for why you should be tied to, a 5-year contract. For installed software, that's maybe a different case, but that's why you see a larger fee up front for installed software. Typically, in that case, the license to use the software is perpetual, but you have to pay annually or monthly for maintenance and support. You can stop that maintenance and support at any time, and you'll live forever with the version of the software that's on your servers. But I would say my number one tip for term and termination rights is to get the right to walk away for convenience for any reason at any time. If it's not going well, but you can't prove there's an actual breach under the contract, then at least you have the right to walk away without paying more money. You might not get a refund, but you won't be liable for all the future amounts under the contract. This is not something that should be mutual. The vendor shouldn't have the right to terminate unless you breach and can't cure that breach within a reasonable amount of time. But really, you've paid the upfront amounts here. This shouldn't be something for your vendor to get out of easily. If it's a less critical software system, termination for convenience, I think, is one of the better ways to easily mitigate your risk without going overboard on the whole agreement. Have the right to get out of it anytime if it's not working out. Let's talk a second about transition, because by now, many of you already have your EHR system in place, but you're thinking about switching to a new system. And really, the contracting phase is the time to start thinking about transitioning to the system you're going to have after that. So think now about transition. when you move to your new system, you're going to need your data. Format and timing can be an issue. It's hard to predict what you're going to need format-wise 5 to 8 years down the road, say, but the contract should require the vendor to work with you to transition to your new vendor. And I think that our opening position should be that the vendor provides your data in the format you request or in an industry standard format. The data needs to be usable to you, if at all possible. That'll save you money down the road on conversion costs, converting your data to the next system. Another thing I snuck in on this slide is some language on sunsetting the software. This goes along with the fact that termination should not be mutual. The vendor should, in addition to not having the right to walk away from this license, the vendor should commit to offering your software or to supporting that software for a number of years. I start with 7, without the right to terminate unless the client has breached. It's a red flag to me if the vendor won't agree to this, at least for a number of years, or if they won't share their product roadmap with you or make long-term commitments, especially if they're requiring lots of money up front rather than just a monthly subscription fee. You may even work into this clause what happens if this language is breached. The client can ask for the remedy to be that they get a license to the replacement system at no additional charge. That's a little complicated, but I think it's worth asking for. This clause often comes up when a small software vendor is purchased by another, often larger software system. We're seeing that happen a lot. It's a lot of M&A action in the health IT space, and we're seeing products be discontinued and clients being very unhappy with the way support goes after the big company comes in and swallows up the small one that you've had a good relationship with. This will help you to shield yourself somewhat from that issue, but it is a difficult issue that can be addressed in a number of ways, including in the way in the support requirements and in the sunset language. All right, moving on. Warranties. The contract should include some guarantees about how the software will function and how any professional services will be provided. These warranties, that language is called warranty, and it's a breach of the warranty. A breach of a warranty is typically grounds for termination of the contract if the the vendor can't cure that breach. I've got a list here of some of the warranties you want to ask for. Something else to keep in mind is what's the remedy if one of these warranties is breached. I mentioned that termination is sometimes, often, a vendor will include language that says the remedy for breach of warranty is to fix the software or to redo the services, and that's the sole and exclusive remedy, rather than giving a client the right to terminate and even possibly get some money back. So watch out for that language, that sole and exclusive remedy language. Some more, this is another kind of risk mitigation provision, limitation of liability. This is a cap on the vendor's and the client's financial exposure in the event of a dispute between the parties over this contract. Often a vendor will include language that says their liability in connection with the dispute is limited to the number of the fees that the vendor has received, say in the last 6 months or in a year, or even if they're generous, total under the contract. That's not quite what I like to see. You might need a larger cap on that, especially if the breach is early on. I'd suggest that the overall cap on liability be a multiplier of fees, say 200% of the fees paid, 300% of the fees paid, and also that this limitation of liability should have exceptions, or also known as carve-outs to the cap. So that's where I've listed here. There should be no limit on vendors' liability for their breach of the business associate agreement or any other HIPAA violation. As we have heard, or maybe you've experienced that those costs can be pretty high. And the vendor's financial liability for breaching PHI should not be limited just to the license fees that you've paid them thus far. Other exceptions include security or confidentiality breaches, which goes along with the first point, Their indemnification obligations, which I'll get to next, fraud, gross negligence, intentional misconduct. Also, mutuality is a good thing here. I know I noted that on the slide, but there's no reason why the client's liability shouldn't also be limited similarly to the vendor. All right, next up we've got indemnification from the vendor and insurance. Indemnification, that means that if you as a client of the vendor are sued because, let's say, the software that you're using at your hospital infringes another company's patent, the vendor will step in and defend you in that contract and pay all costs. So I'd say the number one area where you want indemnification from your vendor is for intellectual property infringement. Those fights get costly, and really that's not the client's issue. Another place you should ask for indemnification from your vendor is if the vendor breaches privacy or security clauses of this agreement or breaches warranties, and you, the client, are sued for that. The vendor, ask the vendor to handle that defense for you. Insurance, especially if you're working with a smaller software company, I suggest adding contract language that states the vendor will be covered by insurance. I've listed a couple types of insurance here. You might also include a minimum insurance limits. Client might be asked to be named as an insured under the policy, and often we'll ask for documentation of those insurance policies and notice if any of those policies change. Those insurance policies are going to cover the vendor if they need to indemnify you or if PHI is breached and costs get out of hand. So it's in everybody's best interest to make sure that the insurance coverage is appropriate under the circumstances based on the risks you've assessed. All right, I've got two more clauses here. I think we're running right about on time. A big clause, a provision in health IT contracts, particularly when we're talking about cloud-based systems or software as a service, is data privacy and security, because your data is on their server at their location. In addition to contract language, here is a really important place to do your due diligence, as I talked about before. But the contract should also address security. It should describe, should state that customer data is confidential. There should be limits on the vendor's ability to use the data. Include baseline security procedures. Sometimes I'll even attach the vendor's security policy as the absolute minimum that the absolute minimum security obligations of the vendor. The contract might address breach notification and resolution procedures, including who's paying for what. Data backup obligations, how often is it done? What's the format of the backup? How is it stored? Again, in a cloud-based system, the client doesn't have any access to the data, so you don't have the ability really to back up your data, and that obligation is on the vendor. So make sure that obligation is in writing. And disaster recovery, business continuity. If something were to happen to the data site, the server location of the vendor, what do they have? What systems do they have in place? What redundant systems do they have in place to make sure that you can continue to operate? One benefit, I suppose, of using a cloud system is that you as the client doesn't have to don't have to pay yourself for the business continuity issues like fire, safety, and physical security, an overheating server room, but you want to know that your IT vendor has thought a lot about it, which I'm sure they have, and that they have procedures in place. Another thing to consider here is to get the right to conduct an audit, a security and privacy audit of the vendor, or require the vendor to have third-party security audits conducted. There's some standard organizations, and there's some standards that have been set by different organizations for what those security audits should look like, and ask for the results of those if you're going to require a third-party audit. All right, the last bit of provisions in a health IT contract I want to talk about are support and maintenance and service levels. So support and maintenance terms might already be included in the general terms and conditions, or you might have a separate agreement here. But it should address that, these terms and conditions should state that the client gets all updates and upgrades so long as it's paying for support and fees, and that you as the client gets what everybody else gets. If there's an update that's generally offered to all customers, that you as the customer gets it too. If you're on an installed system, you should have the right to refuse or delay an upgrade, particularly if training would be required to this new update, or if you'd have to incur other expenses like getting a new software, getting a new server, or updating your Microsoft software to comply with this new update. If you're on a cloud-based system, the updates and upgrades are happening on the vendor's end and are sort of out of your hands. Again, if you're using an installed system, you want to see the vendor agree to support prior versions. So if you have refused to do an update or asked to delay an update, that you want to know that the vendor will continue to support you at least a version or two back. And if you're paying for, you'll often see support and maintenance is tiered. So maybe you've got a gold option, silver option, or a gold option, or a platinum option, let's say. So consider the benefits and drawbacks of the more expensive support and the benefits you get from it. All right, and finally, service level. I talked about a service level agreement being one of the elements of a health IT contract. The SLA, as it's sometimes called, often addresses system uptime and response times. So particularly for a cloud-based system, that the software will be generally available 99.5, 99.7, 99.9% of the time, excluding planned downtime. When you see an SLA, you'll want to look closely at the way uptime is defined, because you don't want, there'll be certain things that just don't count against that. Perhaps the vendor will set up a window of time when they can do updates and the system would be unavailable, say, overnight or Sundays at 2 a.m. That probably meets your needs, but that's something to watch for, because the definitions can really undercut the actual guarantee that you're getting. The SLA might also address support, response time, and resolution time. So if you are having a downtime incident, how soon will the vendor call you back, and how soon will they fix the issue? Failure to meet these guarantees should result in a credit, and by credit I mean money back on your support and maintenance charge. The credit could increase based on how bad the vendor performs that month or that quarter. And often never included, but suggested, is the ability for you as the vendor to terminate for repeated service level agreement failures. Say they miss the uptime 2 or 3 times in a rolling 6-month period. I think that's bad enough performance to give you as the client the right to terminate this agreement. So with that said, that's the last I have on key provisions on health IT contracts. Don't think we have any questions right now. Briar?
I think that's right, and so I think that means we covered everything perfectly, and there couldn't possibly be a question. But if there is, after we sign off here, you can certainly email me or Carrie.
Yes, please.
And our information is on that final slide. And, the next slide, I think. And then the reminder that you can go to the SlideShare website to listen to and watch this and other webinars that we have presented and will present in the future. So thanks a lot for tuning in, and we will talk to you soon.
Yeah, thanks for listening.